Hello and you're welcome to PPL422 Landlord 2. This is our third lesson video and today we'll be looking at co-ownership of land rights. Hello, and I'm excited to have you join us again for PPL422 Landlord 2. Remember, Landlord 1 we majored on customary land tenure. Landlord 2 we are now looking at the Land Use Act and other statutes that guide land law in Nigeria. And of course, we have had some topics and I hope you have found them interesting. So today we are treating another topic that will enrich your knowledge on land law and prepare you, to practice well as lawyers in this very interesting and rewarding field. So let's not waste time. Let's go on and see what we have for today. So at the end of this lesson, you should be able to define terms like co-ownership, joint tenancy, and tenancy in common. You should be able to identify their elements. You should be able to explain how joint tenancy and tenancy in common may commence or be determined. And you should be able to discuss joint ownership of land or joint ownership of property between husband and wife. So what is co-ownership of land? Co-ownership means where more than one person has ownership interest in land. So please note, it's not just any type of interest, it's ownership interest in land. And it can arise in many ways. It can arise by a grant, it can arise by a device in a will, or it can arise by the pooling of resources together to acquire an interest in land. Examples of co-ownership in land will be your joint tenancy or tenancy in common. If you look at the image for on this slide, you can see a block of flats. Now, everybody would have an interest on the land, so that is. Now to joint tenancy. Joint tenancy is the ownership of land for two or more persons by two or more persons without any words of severance. So if land is granted, for instance, in a will to two people, and you just say, I grant to Ada Obiageli and to Ada and Obiageli my plot of land, without saying which share each person will get, what they will have is a joint tenancy. No individual will have an individual interest apart from the other owners. And then upon the death of any one of the joint tenants, it is the surviving joint tenants, the other joint tenants, that will inherit his interest. His family members cannot inherit. That is what is called the principle of jus accrescens. Now, what you must bear in mind are what we call the four unities. This is how you identify that a relationship that exists where co-ownership is concerned is joint tenancy. Four unities. There's unity of possession, unity of interest, unity of title, and unity of time. Possession, everybody, has a right to possess any portion of the land. Nobody can lay claim to one particular part to the exclusion of others. Everybody has the same interest, right? Everybody has the same title. Their title is derived from the same source. So if it is a will, for instance, it is the same title. Everybody enjoys their interest at the same time. Their enjoyment of interest started at the same time, and no one enjoys more than the other. Those are the four units. Now, how do you sever a joint tenancy? Why would you even need to do that? You need to do that to prevent, the principle of jus accrescens. So different tenants want to be able to give to their, when they pass on, for their survivors to enjoy their interest, their family members or who they choose. They don't want the surviving joint tenants to enjoy to the exclusion of their loved ones. So they need to sever the joint tenancy. And you can do it in many ways. You can do it by partition, whether individual the parties agreeing on their own, or a court making an order of partition. Either way, there will be a deed of partition executed. You can do it by sale, where one of the joint owners sells his interest, and that for that you can see Mayo, Remayo, and you can see the case of you can do it by alienation to a stranger, where one of the tenants alienates the land to a stranger, but not by will. So in Ipaye and Aribisala, the alienation was by mortgage, right? Two brothers had joint tenancy over land that they, got from their mother. Their mother gave to them in a will, and then the elder brother who had the title deeds entered into an equitable mortgage, and then, with a third party, and it was held that the joint tenancy has been severed. You can do it by the acquisition of greater interest by one or more of the joint tenants. This can be really majorly a question of fact. And then, of course, if all the parties agree, they can just go ahead and sever the joint tenancy. Obligation to provide shelter for his wife while a marriage subsists. Where the husband, for whatever reason, is dissatisfied and decides to move out, he must provide accommodation for his wife, or if he wants to send his wife out, or render her homeless, the law will expect him to provide alternative accommodation for her. And that is what happened in Ogedengbe and Ogedengbe, where a man demolished the house, and the court held that he needed to look for alternative accommodation for his wife, that it was an obligation that he had to. Okay, so let's quickly do one activity. So I'd like you to think about, we talked about elements of joint tenancy. So think about the unities and mention them, think about them and what they entail. We'll just take a few seconds to think about that. Okay, going on, let's now look at tenancy in common. We have looked at joint tenancy as a form of co-ownership. Now, joint tenancy is also co-ownership, but the difference is that there are words of severance. So joint tenancy is ownership of land by two or more persons with words of severance. So for instance, in a will, I say I give to Okoro and Daudu, and I say the shares in equal shares. So each person knows his part. You take half, Okoro takes half, Daudu takes half, right? That, so what they have, even though the land is one big lot, what they have is tenancy in common. And of course, tenancy in common is not subject to the principle of jus accrescendi. Can you remember what we mean by that? Inheritance by surviving joint tenants. Okay. Because of the interest of the um, third party to whom the land had been mortgaged, the court therefore viewed what was actually a joint tenancy as a tenancy in common, so that justice could be done to all the parties. Okay, now let's differentiate between a joint tenancy and a tenancy in common. From all that I have been saying, you can just imagine, you would know them, but let's just state them. First, remember the four unities. Only one unity operates for a tenancy in common. For joint tenancy, all four unities must operate: interest, time, title, and possession. For tenancy in common, only possession, right, operates. And then, of course, for joint tenancy, there is jus accrescendi. For tenancy in common, jus accrescendi does not apply. And then, under the Partition Act of 1868, of course, by the year 1868, that it's a statute of general application. It's an English law. There is voluntary or compulsory partition of a joint tenancy, to make it tenancy in common. Okay, now how do you determine a tenancy in common? How do you bring a tenancy in common, to an end? You can do it by partition. Either the parties, as I said, partition on their own, or they partition based on the order of court. It can be done by sale. If one party sells its interest, the tenancy in common has come to an end. And then, of course, a co-tenant in common can acquire the interest of another tenant, and then, of course, the tenant has come to an end. So let's do another activity. So I need you to differentiate between a joint tenancy and a tenancy in common. Think about it. We mentioned the differences. Okay, so in this lesson, we have learned what we mean by co-ownership of land, and we have looked at two specific examples of co-ownership, joint tenancy and tenancy in common. We have listed the elements of each form of co-ownership. We have also looked at where joint ownership can be inferred between a husband and a wife, and the husband's obligation with regards to accommodation for the wife. We have also looked at the way each form of co-ownership is created and how they are brought to an end. Download the video. If you have any questions, post it on the discussion forum, and then we will try and answer them. And again, try to do the activity so you get used to them and get used to answering questions. Okay, so until our next lesson, thank you for watching and see you